Welcome to this explainer. We are jumping right into a totally fascinating legal dispute out of South Africa today. It started off as this massive, messy fight over money, but it actually ended up becoming an absolute masterclass in how a government should run. So if you want to understand the delicate balance of power and exactly what keeps a state functioning smoothly without, tearing itself apart, you are in exactly the right place. Let's get into it.
So, have you ever stopped to wonder what actually happens when different parts of the exact same government completely disagree? I mean, we're looking at a case here where local municipalities literally took the president of the Republic of South Africa to court. Sounds like a full-blown constitutional crisis, right? Or, at the very least, a wildly awkward day at the office. But as you'll see, the way this whole thing was handled set an unbelievable precedent for how a state should operate. To set the scene, on one side, we have three district municipalities located in the KwaZulu-Natal province: Uthukela, Zululand, and Amajuba. They're our applicants. And on the other side, well, they sued a staggering 67 respondents. We're talking the President of the Republic, the National Minister of Finance, the Minister of Provincial and Local Government, and dozens of other state entities. It was an absolute heavyweight showdown.
Section 1. The Municipal Money Fight.
Now, you might be wondering, what could possibly push three local districts to sue the top executives of their own national government? Well, to get it, you kind of have to understand how South African local government is sliced up. You have categories A and B. Those are your self-standing and local municipalities. Then you have category C, which are the district municipalities that coordinate everything over a much broader area. The drama kicked off with the Division of Revenue Act of 2001. This act decided who got what from the national budget. It gave a totally fair cut to categories A and B, but it literally left out category C. Just nothing. The district municipalities were basically defunded from the national equitable share for that entire year.
Naturally, those category C districts weren't just going to take that lying down. They went straight to the Natal High Court. And guess what? They actually won the first round. The High Court took one look at the Constitution, which guarantees local governments a fair share of revenue to, actually provide basic services, and they totally agreed with the districts. The court officially declared Section 5.1 of that 2001 Act unconstitutional, specifically because it left out the Category C municipalities.
But here's the catch. Winning in the High Court, that is not the finish line. In South Africa, a High Court ruling that strikes down an act of parliament means absolutely nothing until the Constitutional Court, the highest court in the land, actually confirms it. It's a built-in check and balance, so laws aren't just tossed out randomly. So the whole case had to pack its bags and move up to the Constitutional Court for a confirmation hearing.
Section 2. The Unexpected Legal Twist. Just as everyone was bracing for this massive Constitutional Court showdown, the narrative takes a complete pivot. Back in 2001, we had that High Court ruling. But then, fast forward to April 2002, the government actually stepped in and repealed the controversial 2001 Act, replacing it with a brand new 2002 Act that properly included the district municipalities. Problem solved, right? Well, early May rolls around, and the parties even reach an out-of-court settlement where the national government agrees to pay the districts to make up for the shortfall. The hatchet is officially buried. Yet, wildly enough, on May 14, 2002, the Constitutional Court hearing happened anyway. So picture the scene at the hearing. The applicants stand up and officially withdraw their demand for the 2001 payment, because, they already settled that out of court. But the application itself, the one asking the highest court to officially declare that old, completely repealed law unconstitutional, that was still totally active. The Constitutional Court was sitting there with this pending confirmation staring them right in the face.
Section 3. Cooperative Government Explained.
And this brings us right to the real climax of this explainer, and the true lesson hiding underneath all this financial drama. The money has been paid. The bad law doesn't even exist anymore. So why on earth does the highest court in the land need to burn its valuable time ruling on a dead law between parties that already hugged it out? That was the tension the court had to resolve. The answer to that question is tucked inside this really brilliant concept, cooperative government. You'll find it right in Chapter 3 of the South African Constitution. Essentially, this principle says that organs of state absolutely must avoid taking each other to court. Think of it like a family feud. You wouldn't drag your own sibling in front of a judge before you at least tried to hash it out at the dinner table, right? The Constitution explicitly demands that, whenever humanly possible, you resolve disputes politically, not through aggressive litigation.
And the Constitution wasn't just throwing out vague suggestions here. It actually built the literal dinner tables to mediate these exact kinds of fights. For example, the Intergovernmental Fiscal Relations Act of 1997 set up something called the Local Government Budget Forum. This brought together the National Minister of Finance, provincial reps, and local government folks all into one room. If those district municipalities were upset about their funding, they had a strict legal obligation to exhaust these political avenues, like talking it out in the budget forum, long before they ever drafted a lawsuit. There's a quote from the Minister of Finance from that time that perfectly hits the nail on the head. He pointed out that the system was already mature and flexible enough to handle these unintended consequences. And that's exactly what that missing funding was, an unintended mistake in the legislation, not some malicious conspiracy. The national government was totally willing to fix it politically without needing a massive, expensive court battle.
Section 4. The court's final verdict.
So, keeping all that in mind, knowing the mediation tools were right there and the government was ready to talk, how did the Constitutional Court react to these state entities suing each other anyway? Well, in an absolute boss move, the court made no order at all regarding the confirmation application. They just flat out refused to decide the dispute. They looked at the whole situation, took a step back, and declined to give the applicants the constitutional gold star they wanted for a law that was already dead.
Now, why just walk away? The court gave 3 very clear reasons. First, because of the new law and the settlement, making an order would have 0 practical effect anyway. Second, and this is the big one, the parties completely failed their constitutional duty to use those political dispute mechanisms first. They totally jumped the gun. And third, because they settled at the very last minute, the court was robbed of hearing a proper, robust legal argument on some really complex issues. Basically, the court reprimanded them, cementing the rule that the state functions best when it talks to itself, not when it sues itself.
I want to leave you with this final thought to chew on. When we step back and look at our civic systems, what actually builds a healthier, more functional democracy? Is it government departments aggressively suing each other the second something goes wrong? Or is it rolling up their sleeves, sitting at the table, and mediating those complex problems together? The Constitutional Court made its stance crystal clear. Thank you so much for joining this explainer, and keep asking the big questions.